Intervention is the inherent right of every state to govern itself, choose its constitution, amend it legally, and from alliances and treaties with other states or other organs. However, as Lawrence notes, there are times when another state or group of states intervenes, trying to force the state to act against its own interest or to refrain from action it would otherwise take, and this type of interference is known as intervention. So I know it is not easily understandable. So basically intervention is in international law refers to interference by one state or a group of states in the internal or external affairs of other state. This concept is rooted in a principle of state sovereignty, which grants each state the inherent right to govern itself, choose its constitution, and choose amended constitution legally, and from alliances by the constitution, and treaties with other by constitution. Means you can in a sovereign state you can do anything legally by the constitution. However, as noted by Lawrence and discussed by MP Tandons in Public International book, uh, there are instances where a state intervene in the affair of another state. These interventions can take various forms, such as political, economic, or military actions, and is often amid aimed at influencing the state's decision or actions. The key aspect of intervention is that it involves coercion or pressure, compelling the state to act against its own interest or to refrain from actions it would otherwise take. So we can see in this discussion that there are three types of discussion: political, economic, and military. And uh, to give an example for political interventions, uh, like diplomatic pressure, by putting diplomatic state pressure to the state, and economic pressure is sanction, giving sanction or financial aid, and military intervention means peacekeeping, like for example peacekeeping missions of United Nations, support for rebel group. These are the types of intervention. And justification and legality intervention is a continuous issue in international law, while the principle of non-intervention is ancient in United Nations Charter. These are explained where the intervention is considered justified as such. So there can be justified illegally by humanitarian intervention for the humanitarian purpose, self-defense. If the state is attacked or face imminent threat, it may seek assistance from other states or even. So it can be legally justifiable. Consent, if the government or state consent to intervene, they ask to intervene to their country, so it can be justifiable. So there I have some controversies and challenges. Like for example, the concept of intervention is fraught with controversies. Critics argue that it often serves the interests of powerful states rather than the well-being of the targeted state. There are also concern about long-term impacts of intervention, such as destabilizing agitation or loss of sovereignty and the undermining of international law principle. In summary, while intervention can sometimes be justified under specific circumstances, it remains a complex and highly debated issue in international law. The balance between respecting sovereignty and addressing global concern like human rights violation continues to uh, challenge international community.